to you about preferences. I currently have a consulting firm called Balanced Housing Solutions. My background's in fair housing. Many of you might know me from HUD Fair Housing. That was what my job was up until last summer. And I was recently the regional director of the Office of Fair Housing for HUD Region 8. And preferences, that is a little bit of a niche area in some ways, but an area that I really like exploring. Some of that as we dive into here and we talk some historical background about preferences. There's a lot of history with preferences, but as they've evolved in different ways, there's not a whole lot of precedent to understand how to navigate them lawfully. And when we come at this today, we're going to come at it from it's talking about how to make lawful preferences. And so what I'm trying to relay is how I've always thought about these. So my background before this private consulting firm, in which we specialize in compliance with fair housing laws, was enforcement. I was an attorney in Illinois, and I was primarily a fair housing attorney, and I was a plaintiff's attorney. And then working for HUD for over 17 years, my role was enforcement. So I think about that to try to, as enforcement is our gateway, it seems like an obstacle because what we want to avoid, right, is enforcement. If we have put in place a preference in our housing selection process, we want to avoid some sort of an enforcement scheme. But I think when you think about that being maybe an obstacle to employing lawful preferences, well, then we can leverage that. So if we think about that, that's my way I go at it now. Some of that's just because that's how I think, right? That's how I analyze issues is it lawful or not? So I'm going to share my screen and hope this works. And then I need to swap my notes to the big screen because I had a lot of notes. So this is a topic that when we get to the back end of this session, it's really probably a 3-day seminar on the different specific fact scenarios. We'll see when we get to scenarios in the second part, the second hour, that there's really so many different ways that a fact pattern can go if you're contemplating a development project in a proposal stage or if you're operating housing. So I call this on the top line, state of fair housing. I know the title is the bottom line, structuring housing preferences without violating fair housing laws. But I really think that this is where we're at in 2026 and how preferences has evolved, especially from a fair housing component, how fair housing looks at preferences. And we'll go through this. Now, this first part of this session is foundational. And there might be points where you're like, Whiteside, why are you telling me things that I hear in every fair housing training? Hopefully it's going to be a little bit more deep than that. But really how we're kind of trying to approach that is from the foundational to try to demystify it. Because if we understand how to analytically think about how the preference operates and whether or not it's lawful and what the risk factors are involved, that's going to help us better understand whether or not we should deploy those preferences. So this conversation matters today because preferences have evolved. The preferences started as an exclusionary tactic or exclusionary strategy, exclusionary selection process. So preferences and their predecessor, the requirement, have long been a civil rights concern. But we've seen them expand in different ways and almost sort of flip the conversation on whether or not it's a fair housing issue or whether it's an actual tool to further fair housing. But by default, because these are exclusion tools, they're going to mean increased scrutiny. And when we get into this, I think obviously I left an employer last year, which has really changed its messaging on a federal level. And that shifting federal landscape and the sort of maybe the mixed signals that we get on understanding what the priorities are in the federal law, it really doesn't equate to a reduced legal risk because the way these fair housing laws apply has not changed. So what we'll cover today, we're going to talk about the evolution of the housing preference. So we're going to talk about what a housing preference is. That's probably our simplest line to be able to talk about today. And then we're going to talk about foundationally how to assess the preference and what type of framework we want to think about when we scrutinize housing preferences. And that's going to really tie back into how historically preferences have been used in operations. And yes, we're probably going to be talking a little bit more about the ways it was used poorly, maybe, and I would say it's more like intentionally done to discriminate, as opposed to now we've moved from a different way. And we want to keep this, and from an assessment standpoint, simple. And we're going to get into like how to keep this in a more simple format. So if we keep things simple, it's going to help us better approach and prepare for different strategies to be able to get the end goals we might look to achieve when we put in place a housing preference. The legal framework is going to be really important because we need that foundational knowledge to understand what the protected class is, both on the federal level, but also on the state level. And then also we have to think about, if we're operating a program that gets federal financial assistance, we're going to put home dollars in a multifamily development. That's federal financial assistance from HUD. What does that mean if we are thinking about preferences? Also, we're going to touch upon, because there's a lot of discussion here regulatory wise, how PHAs have preferences in the regulatory guidance as well. And so that's going to mean that there is continued relevance in how we look at these different understandings. We're going to talk about fair housing generally. We're going to talk about the Colorado protected classes because I think it's important from a conceptual standpoint. But at the same time, we're really thinking about this primarily through the lens of the Fair Housing Act, which is going to be enforced similarly in Colorado, with the exception of the greater protected classes and some nuances. We're going to think about that historical starting point with local preference to moving to the live work, to the community, to the anti-displacement measures. And that's going to set us up to being able to understand how to analyze whether or not it's lawful, because preferences, as they're put in place, they can serve legitimate policy goals. In 2026, across the country, there's very good models of how they're using to integrate vulnerable and special need populations as opposed to exclude. That pushes sustainability, that also uses targeting of resources when resources are limited. But because of the risk attached to it, if they're not carefully structured and implemented and tracked and assessed and reassessed, those preferences can still run afoul of fair housing laws, either from effect or an intent. So we want to think about this discussion. Again, there's going to be a lot of foundational stuff in the first. Think about your preference, though, idea, and then try to employ those practical ways in which you want to think about that to understand how they could be designed to align with not just the goals, not just the community goals, not just the program goals, but operate consistent with the different civil rights requirements. So we want to emphasize how these preferences are going to be evaluated from a regulatory standpoint, by the courts, by enforcement agencies, and then leverage that to mitigate risk through, when deploying a preference, do it thoughtfully and design documentation. Like I said, you're going to hear me say reassess a lot as well. So first, I have a very simple poll. It's not overly complicated. It's in 3 parts. The first question for the audience is, do you currently employ a preference? Malia, how will I see the poll?
Yeah, just if you go to the next to the chat icon, there should be like the 3 dots, or we call it the waffle icon, and then there will be polls. There should be a polls button, and then you can see the votes on there.
I don't see the poll. Tony might have the same problem.
Oh no.
Well, interesting time. We'll just walk through this.
Yeah, I can let you know what if you want me to give you the answers right now to the first question.
Yeah, what do we have on the first question?
So we have 14 votes for no and 12 votes for yes for using a preference.
Okay, so those who are voluntarily participating, which we'll get to in round 2 of this second hour. So we got about a 50-50. So for those who voted no to question 1, in the housing program that you are connected to, would you want to use a preference?
So far on that question, we have 10 votes for yes and 4 votes for no.
Okay. So then going back to those who voted yes on one, if you have a preference in place, are you considering expanding your preference?
Yeah, and it looks like on that one, we're about 50-50. 9 votes yes, 9 votes no right now. Oh, 10 votes no. So it's changing a little bit, but pretty close.
But still, that is a great deal of interest. And I assume the concept of why you're here today is either have a preference or we want to have a preference. And then I'm just going to assume everyone's got non-discriminatory motives behind their wish for the use of preference. So this is going to be really good because this is going to be good to understand how you need to think about your current preference. Because again, preferences are a lot about reassessing, not just assessing when it's put in place, but actually reassessing throughout to see if it's meeting the program goals as well as to see if it's complying with civil rights requirements. So this is going to be a good stepping stone to think about, okay, now we're going to build that foundation. And the first part we want to think about is something incredibly simple. So what is a preference? Preference is priority and selection, right? Priority and selection, priority and eligibility. You're reordering the access to housing. And so I have this incredibly in-depth picture on the screen that shows what's the first way to think of preference. Preference is about tenant selection. It's about resident selection. It's about applicant selection. So it's about those who are able to access the program. And similar to, you'll see this wonderful visual. If 3 years ago, you're watching me give a training on tenant selection and the use of third-party screening and algorithms, you would have seen the same picture. The reason why is because that's how a preference is just another rule we put in place. So we have applicants come for our program. And I'll say program broadly, because as we'll get into a little bit, preferences involve all kinds of different programs, from affordable housing programs to purchasing programs to municipal programs that allow access to housing in different ways. So they really think broadly of the different way that preferences could be brought into place. So homeownership, rental, et cetera. But it's just another rule that we're going to place amongst our varying other tenant selection policies. So that is what we're doing. So we're taking the applicant's going through that rule machine, and then we're coming out with a decision. That decision ends up being the prioritization on who gets selected for that program, how selections are made, trickles down to maybe how order of priority is made on a wait list. But at the end of the day, this is about applicant going through our rules, and then at the other end, we're going to see a decision come out of that. So how do I question a preference? So we have this simple mechanism. Okay, we have a preference, put a rule in place. I think someone put something in, like our AMI is included in preferences. Well, I mean, in a way, AMI is another rule. So it depends how broadly you want to think of preference. AMI is usually an eligibility requirement though, so that would probably be different. But out of the ways we select, we put this preference, we put that rule in, and then we come out with a decision. So from thinking from a lawful standpoint of how you get there, well, how to question a preference? How do I initially, either in preparation or an assessment, how do I question whether or not a preference is lawful, whether or not it's even just proper? And it's just the two questions that come up in discrimination law. Does it intentionally exclude an individual or group of individuals? And is it based on a protected class? Does the policy operate to have a discriminatory effect on a group of individuals? And is it based on a protected class? And oftentimes when we talk about preference, I think a lot of the dialogue and maybe some of the concern with it, because it's a valid concern about the risk, is the effect piece, that second piece. But we must never affect that there's intent. We have intent about why we put a policy in place. So when you have a policy related to preference, and now that's going to tie back in, obviously, to some of our discussion historically, how preferences were used. But intent is the first step. So why is the policy there? What is the intention of the policy? Because these preferences are going to operate as a policy of limitation and exclusion. And then secondly, effect. And we want to use these two simple frameworks to be able to ask ourselves questions, to be able to assess specific preferences. I go back. This is something I've used for years. This is the best way I can think of framing. And this on the screen you're going to see relates to racial exclusion. And this obviously is not just a talking point, but the genesis of pushback on the civil rights concerns that surround preferences in of itself. But for myself, I've always found it really helpful for really since I started looking into preferences, which predates my time with HUD and questioning them of how to frame the issue. So we are going to think about this, but we have to think about historically how they've been used. So the question of residency preferences raises fair housing concerns when it's applied to a geographic area that has virtually no minority population, since in such a case, the preference is likely to have a racial exclusionary effect. It's fairly intuitive for us, right? When an effect of a local housing policy is racially exclusionary, it violates the Fair Housing Act by both making housing unavailable and perpetuating existing patterns of segregation. And those are two pieces there, because I think it's really important of how I always wanted to frame it, is that there's in this instance, and it was the fact of the case, which we'll get in later, but there is intent there. There was an intent to make housing otherwise unavailable or deny housing to minorities. And then the other way is the effect. Segregation, perpetuating segregation, segregative effect, those are claims of discriminatory effect. So thinking about it in two simple sentences of how we want to frame this. Again, this is very foundational, so just bear with me. We're going to get complicated in hour two. And another way I think about it, and this is a housing authority case, and again, these are intuitive principles. Where a community has a smaller proportion of minority residents and does a larger geographical area from which it draws applicants, a selection process that favors its residents cannot but work to have a discriminatory impact on minorities. And the reason why both of these are helpful, because I think conceptually for me, I've always thought, okay, here, what's going to be intuitive? Where a community has a smaller proportion of a protected class group of residents than the larger geographical area, or the larger metropolitan area, or the larger market area, or the market area generally, well, then that process is naturally going to favor residents, and it can work to have a discriminatory effect on that protected class. So breaking it down like that, I understand you're probably thinking, well, that's a little too simple. No, let's try to keep it simple now, because I think the intuitive part about it is really important to think about. Like the flagging of the preference in itself is extremely helpful of knowing why it's problematic, because it's intuitive in your head to think, we're going to exclude individuals. And that means we're going to favor a group of individuals, and that could have a discriminatory effect. Another way that preferences get problematic is a preference is a rule, policy, or practice. So when a municipality, when a public housing agency, when a housing provider, when a property management company puts in place a preference, that is simply a rule, policy, or practice. So it gets lost in the wash a lot is when you have a rule, policy, or practice, you got to consider reasonable accommodations for individuals with disability. So we understand, this is probably boilerplate language. Everyone here understands, I know it's discrimination to refuse to make a reasonable accommodation, rule, policies, practices, or services because they could be necessary to afford such person equal opportunity to use and enjoy dwelling. The availability to make the request. I always kind of talk about everyone has a right to request a reasonable accommodation, or have the right to request accommodation. But for our framework of thinking about whether, I think a lot of people think, well, if you're disabled, then you automatically are going to be in. At the same time, you to be an individual with disability, and then the request for the accommodation has to be necessary to afford you, individual with disability, an equal opportunity to use and enjoy the dwelling, so be able to access the housing. So this is something that gets lost in the wash when preferences are employed, is that they don't take into account that they have a rule, policy, or practice that has to be accommodated from it. And it ends up being an exclusionary rule that gets per se unreasonable, but actually not going through the analysis to assess whether or not that rule is actually not reasonable. And then if you have federal dollars, you have 504, you might have the ADA. And then you have this larger breadth of affirmative obligations. You again have a rule, policy, and practice. Let's say like HUD regulations, it doesn't have a regulation that just simply states housing accommodations. It has one that says housing adjustments. So it talks about that recipient of that dollar of federal money to modify policies and practices to ensure that those practices do not discriminate. But then also to ensure that they don't impose upon individual with disabilities other policies that have the effect of limiting the participation of tenants with disabilities in the recipient's federally assisted housing program activity. This is really important because as preferences have evolved, we've seen a number of vulnerable and special needs populations, well-intentioned policies put in place to target those groups for housing. And if there's federal dollars, that changes the discussion and changes the analysis of how we have to understand of whether or not, if that's a preference, whether or not that's lawful. Hopefully people recognize another great tool. I went back to a real generic tool, something that always meant so much to me as a HUD employee, which has actually got great little nuggets and pieces of fantastic, simple ways to approach marketing in housing programs. And this is an affirmative fair housing marketing plan. And yes, in this, we have some really good foundational knowledge on residency preferences, because this is going to ask us some questions. Do you have a preference? What's the geographic area? What's the reason for having a preference? If you have a preference, it can't be speculative. It's got to be based on, I'll just say based, the pun intended, based on a reason. It has to have a legitimate, justified reason. And then what's so important with preferences, how do you periodically evaluate your residency preference to be in accordance with non-discriminatory requirements? You can think about this framework for, you don't take out the residency piece of it. You can just, who are you going to serve by your preference? What's the reason for having your preference? And then how will you periodically evaluate your preference to make sure that you're complying with civil rights requirements? And then I did the snippet a little bit bigger, because what I like about here is that the inclusion right after this wasn't always like this in the plan, is the connection right away to the marketing. Because one of the things, if you have a preference and you're worried about mitigating risk, one of the most better ways to do that is through the marketing mechanisms that you have and outreach. One, because those might be less, you might be able to less discriminatory means in which you operate a preference, but still serve the population that you're trying to serve. And then also, that's a way to mitigate the risk and being able to create an integrated community. And of course, there's a worksheet in this wonderful plan. And yes, this is residency, but you could think about this when you look through these demographic characters. The full plan goes through the race and national origin categories, also has families with children, also has individuals with disabilities. So it creates a framework of which we can evaluate and assess the residency preference, and to be able to compare that against our protected class populations to understand if something's going to be identified as problematic, as higher risk, or something that's going to require us to reassess why we employed the preference to begin with. So preferences operate in different manners. Selection criteria, eligibility criteria, how we manage wait lists, they can come in different ways. How we weight the preference, maybe it's for a certain number of units or a certain level of participation in a program. And traditionally we see these as local residency or local workforce. The stated goal is to support the individuals that live and work in our community. I'll answer that question later. Andrew, I got you. That's a quick one though. Expanded market area is generally thinking of like a CBSA. So it's probably easier when you're in Denver area, expand market area. And then it's not always instructive, but oftentimes the expanded market area, if you go back to here, it's a little bit housing market area. We're generally going to think about I would say the general fallback is you're thinking MSA. An expanded market area, you might be thinking of CBSA. Expand, but they're not necessarily overly defined. So it could be, if you're in a micropolitan area, you might look at collar counties to pick an expanded market area. So your micropolitan area would be housing market area. I should have left that one for the break. Sorry, I got distracted. Again, I love these marketing plans. So how do they operate again? Well, we can go back to HUD. HUD has, for public housing programs, it has lists of permissible preferences, residency preferences, working families preferences, persons with disabilities, victims of domestic violence, and for single persons who are elderly, displaced, homeless, or persons with disabilities over single persons. So HUD PHA regulations can be a source of validity for our use in permissible preferences because they come from the regulations. And these are pulled from the tenant-based and the project-based public housing regulations, and as well as Part 5. They're in 24 CFR Part 5 for HUD programs. So very valuable resources to understand just generally, well, what would HUD say is a permissible preference? But again, what we're missing here is something we need to dive into a little bit, is the protected class piece, right? We know that these are generally okay, but that's because preferences per se are not unlawful. Preferences are lawful. How they're implemented and deployed, that could be a different story. There also are hidden areas of risk which could be related to policies, land use policies. And this way I'm thinking about annexation agreements, land use agreements, then which the preference actually starts from maybe this political act, or maybe elected officials make a decision based off of the political will of the people that they want to put restrictions in place for multifamily housing development. That could be an area in which this preference starts. And if it starts that early, oftentimes that could create problems down the road if that policy either did have ill intent, or if perhaps it was going to have a discriminatory effect and you're stuck with these restrictions. Documentation, verification, and deadlines. Those are other ways in which perhaps preferences rear up for applicants, but they're not really truly a preference. It's more thinking of like, is there going to be a burden on the applicants to actually serve as a per se limitation on the number of individuals and how they can apply through a program? It's a little bit more abstract. First come, first serve. That kind of ties in a little bit with the accommodation structure, in that first come, first serve, even though that seems simple, is just a timing mechanism. And maybe it doesn't necessarily relate to the housing per se. It could be an amenity related to housing, but that speed as a proxy for access can have to still make sure it avails itself of civil rights laws. Residency or geographic ties, kind of identifying who belongs and who's trying to enter. What I'm thinking there is this is sort of a preference that maybe doesn't always like pop up as a preference, but the more I think about it in my head, it is a preference. There's preferences in place across the country that provide priority to certain programs to residents' relatives, parents, grandparents, or their children. In other words, we're trying to keep who lives here to get the access to the programs. Traditionally, that's like a local residency preference, and ties to like activity-based preferences and the similar preferences that we usually see. Process can create friction that's similar to the documentation piece of whether or not there's component pieces to a process that actually creates a level of friction that can make it difficult for some people to navigate. And I'm just pointing out sometimes the effect or impact of those who can't navigate that, they might be members of protected classes and decision makers. So you might not think about it, but people who make decisions, they really are determining who gets in, who gets out. So it could be a hidden risk in that it could be subjective preferences, even though that they're not part of the policy. So protected classes, because this is always going to be our first inquiry. So federal and Colorado, but the Fair Housing Act on the left side, and we got the additions that you'll see under Colorado law, CATA, on the right side. So race, color, national origin, religion, sex, familial status, disability. I know I'm going through this quickly, but source of income, creed, which is religion, and then that include, because sex is on the federal level no longer includes sexual orientation and gender identity. On the state level, we still have sexual orientation, gender identity, gender expression, marital status, veteran or military status, and ancestry. And as well, what's not in here, which is in a lot of states and localities, is age, and that can cut against preferences as well. But protected class is our first starting point when we assess these. And of course, if you have federal dollars, if you have HUD dollars into a development, a project, a program, then you have these federal civil rights related requirements. So that's not just the Fair Housing Act and its regulations. That's Title VI of the Civil Rights Act of '64 and its implementing regulations. It's Section 504 and its implementing regulations. And it's Title II of the ADA, as well as the Age Discrimination Act. And it is a statute we do not see come up very often in federal programs. And when it does, it usually relates to preferences. And another little bit of a in the weeds piece here is that there's actually, when there's a duration, there's challenges to preferences in which civil rights laws theoretically come up. What's the biggest civil rights law of all? It's the United States Constitution. And the Constitution, the Supreme Court has always interpreted in the 14th Amendment this right to travel and interstate migration. So how some residency preferences have even gotten more abstract in their challenges and really got, I would say this is kind of in the weeds, but it brings up a point of how that was leveraged to attack durational residency requirements. Residency requirements, I know usually we think, okay, requirement bad, but they were tied up and dressed up in the terms of a preference and required us to reside to be eligible for a live work preference by actually residing in a municipality for 5 years. And so there have been challenges which have been successful and unsuccessful, in which challenging durational requirements based on constitutional protections. So while it's totally nuanced and abstract, generally speaking, bona fide local residency preferences are treated with more deference and upheld if they're rationally related to a legitimate governmental interest, whereas these durational requirements, they receive more scrutiny to be able to determine whether or not they're constitutional. And we settle down into our framework for assessment by thinking about treatment versus impact. Yes, if you go through a fair housing training annually, you'll be like, I know intent and I know impact. But intent and effect is how we're going to determine whether or not these are lawful. Why is this in place? Who does this affect? So discriminatory treatment, that's the intent piece. That's whether the actions with a discriminatory motive. It could be direct, and direct is we put in place this policy to exclude Blacks. That would be direct evidence of a preference being violation of fair housing laws. Or it could be circumstantial, more likely. So circumstantial is going to look at more of a burden shifting formula. So you're going to have to establish, is there a claim that there's a violation of the law? And then it goes to the respondent, defendant, the other side. The housing provider says, well, no, we have a legitimate non-discriminatory reason for this. And then the framework goes back to that, challenging that practice and say, no, that reason is actually a pretext or reason for discrimination. So there is a way, this sort of mechanism to think about how these preferences can be addressed from an intent standpoint, which might not overly be direct. And another good thing we mentioned, don't get caught in the wash on reasonable accommodations. Reasonable accommodation is actually a direct evidence of intentional discrimination if it's denied. So that's another way in which disparate treatment can occur out of the deployment of preferences. And then discriminatory impact. The discriminatory effects actually or predictably results in a disparate impact on a group of individuals because it creates, increases, or reinforces or perpetuates segregated housing patterns because of protected class. Now, you might have heard HUD has proposed to remove its discriminatory effects regulation. However, that regulation really just mirrors what the Supreme Court upheld in 2015. But what's important we need to think about here is that it doesn't, that really doesn't change the analysis of whether or not there is an action that has a discriminatory effect in violation of fair housing law, because the Supreme Court has upheld that this is a cognizable theory of discrimination. And as we'll find, as we walk through this, probably more than once over the course of today, that disparate impact in its framework, it's not an obstacle for us when we deploy preferences. Because again, I'm coming with the assumption that no one's here to put in place a discriminatory housing preference in violation of civil rights laws. So coming with that preference, well, we can think about it as disparate impact. We can think about how this isn't an obstacle to deploying a preference. This actually shows us the way in which we can lawfully carry this out and not just enact it, but implement it and keep it in place in order to ensure it doesn't have a discriminatory effect. So we want to lean into these frameworks. We want to lean into understanding what's the intent behind this. We want to lean into understanding what makes a policy to have a discriminatory effect or disparate impact in violation of fair housing laws. So this is a framework. This is very helpful. This is not I'm paraphrasing here, a burden shifting. Burden shifting is very legalistic. It's very lawsuity, standards of evidence type of stuff. But we want to put this in place because this is going to show us the way. We have to remember that these claims, they remain the recognized method for establishing liability, regardless of federal administration policy statements. Regardless of that, we still have a framework is going to show us the way on how to understand whether or not our preferences are operating improperly. So for our discussion here, Plaintiff first choose the challenge practice cause a greater harm to the protected class than to others. Now, I've tried to simplify this. I put paraphrase because we're trying to think, we want to be able to reassess it. You're probably not going to do 6 to 8 months of statistical analysis and records requests to be able to, and applying a variety of different of scientific methods to produce statistical significance. So it's probably better to think of greater harm to a protected class when you're trying to assess whether or not you might have a problem. The way that the Supreme Court talks about it is proving the challenge practice caused or predictably will cause a discriminatory effect. So it's identifying the practice, it's identifying the greater harm, and the legal requirement would be statistical significance, but we want to think about a greater harm and disparity, that it affects a class of individuals, a protected class, differently when compared to others. And then part of that first step is then legal saying they're going to plead this, but to be able to establish the claim for a violation, there's cause between it. Now, preferences is a little different than some more abstract lending cases and different type of cases that come up under the disparate impact theory, because a preference is probably more likely going to be able to have a straighter line drawn to the effect and to show that causation. And then there's also good nuggets in here, even though this is a burden shifting legal test. Well, because after you establish the greater harm to the protected class, what is that housing provider defendant? What is that municipality? What is that defendant? What do they have to show? Well, they have to show the policies necessary to advance a legitimate interest. That goes to the documentation piece. That goes to the reason. We talked about reason already. That goes to those pieces to be able to understand, okay, what's the legitimate interest here? And was the legitimate interest put in place when we started this? That's going to, whatever, every preference has to be derived from a legitimate interest and understand how it advances a legitimate interest. But then it's not done there. And again, for our risk mitigation, for our design stage, this third piece is very helpful. In the court setting, this goes back to the plaintiff, goes back to the complainant. And they have to show that that valid, legitimate interest can be served by an alternative policy with less discriminatory effect. This is a great teaching point for the deployment of preferences. We're thinking about preferences. Are there less discriminatory alternatives? Because again, in a way, all these policies are going to be policies of exclusion. So there's a chance potentially that they could be limiting. So is there less limiting alternatives out there that can also reach the goals the preferences put in place to achieve? So hidden areas of risk. When you have a preference, when you're developing a preference, when you're considering a preference, when you're assessing a preference, that's what that marketing plan asks every 5 years. It asks somebody, well, you didn't have to put, you could actually put in the marketing plan. It's very savvy housing providers in the marketing plan would say, we are periodically assessing our residency preference every year to determine whether or not it's valid and whether or not it needs to continue. It's a little bit more sophisticated, but that marketing plan's making you go through this. And then we have a framework, which we kind of got to keep in mind, which is simply derived from treatment and impact. We start with our protected classes, then we have the policy. That's your rule. That's your preference. And then we design or develop or look at the comparison of the populations that are being served. Classic way to think about this, and this is kind of how you get to the statistical significance, if you get in the weeds, the abstract statistical piece of discriminatory effect claims, the expected, no preference, observed, with preference, assessing the population groups, and then you don't have to get overly deep into the statistical piece unless you really love running spreadsheets and pulling data from the Census Bureau and doing a bunch of different models. If you don't like doing that, you're really just trying to use your intuition to see if you can see greater harm. Generally speaking, a mere disparity in statistics is not going to be enough to show a preference or a policy violates the law. So if we're thinking about issue spotting, we're thinking about greater harm. If we're thinking about whether or not it's unlawful, we're thinking about a statistically significant disparity. And again, I think we want to think about greater harm, and then we want to think about causation. If there's a disparity, is the disparity because of the preference? I said, the way we're looking at this and running this test, probably, but causation's got to be there for it to violate the law. But keep in mind that first step. Keep in mind your protected classes and what the challenge is and why you have that policy in place. That's the intent piece. Again, it's like I watched a lot of Simpsons growing up. There's a Simpsons episode which Marge says, if you say thing 3 times, people remember it better. You might hear me say that probably 50 times, but repetition is helpful in getting us to understand how to keep this simple, and how to approach this, and how to assess this. Because with preferences, the first inquiry is our protected class groups. This is where we start. When we assess a preference, when we develop a preference, fair housing, civil rights is about people. Housing is about people. Affordable housing is about people. Housing programs, it's about people. So we have this overlapping protected class and housing. And we need to look at that as our first priority to understand where we start to go to assess a preference. What matters? Data is information. Data is going to come to the point of necessary if we think about even if there is a disparity, but before there is ever a disparity, we want to have a legitimate interest of why this policy, this preference is in place. That legitimate interest is then subsequently going to be backed by data. Data is simply information, documentation, records, needs assessment, studies, comprehensive plans. Localized analysis will matter. Right? We want to look at, when we think about residency preferences, the classic way of looking at it is local versus regional. And a really important way to come out, this is stolen from many a case on preferences. That valid interest, it cannot be hypothetical or speculative. It can't be, we want to care for our residents. We're concerned our residents are going to move out of the city. Can't be that simple. That's too hypothetical or speculative. Has to be grounded in legitimate, valid interest backed by information. And when we assess, it's very important. We're looking at, remember, again, this marketing plan just keeps coming up with great ideas. Looking at our demographics of our community, looking at our applicants and wait lists, looking at the census tract where the property is, looking at the property's residents, looking at a market area, generally the MSA, looking at an expanded market area. If you're in Denver, you can look at the CBSA, and then considering our preference group and what the demographics of our preference groups are. And data is going to show you, who's put on the wait list, who's housed, who's let in, who isn't. Again, preferences by themselves, because they prioritize, that means it's going to be limiting and it's going to act to serve in some ways as an exclusionary method. I put another thing that HUD's does, kind of backtracked on the affirmatively furthering fair housing thing. So I put still waiting AFFH, but AFFH is tied conceptually, regardless of whether or not HUD is going to meet its mandate to affirmatively furthering fair housing. Sorry for the critical commentary. I have a disclaimer on page 1 of this slide deck. But even if HUD's not pursuing that, the disparate impact Supreme Court decision comes back to it. It talks about affirmatively furthering fair housing. So I think conceptually, it's still important to our discussion on preferences. Also, a number of states have taken AFFH seriously. If you're in California, AFFH is wed into the state housing programs, and it lives there to the extent that it's not living in HUD presently. But AFFH gives us conceptually another foundational piece, which we're going to be able to take into our part 2 of this discussion today, to talk about the deployment of preference. So conceptually, really, what's a preference going to be deployed to do? It's exclusionary, right? But as it's evolved, we're now thinking inclusionary. So some preferences that get outside the local preference, they're looking for integrated and balanced living patterns. You're trying to provide your housing, your workforce in your municipality might be more diverse than a municipality. And therefore, it's an integrated measure to be able to attach programs to be able to allow people to reside in your city, which is going to provide access to opportunity. So Fair Housing Act, and it still has a role, discriminatory effect, disparate impact, and that continuing role to help us move toward more integrated communities. So preferences, especially when they were historically deployed, they stood at that edge of the cliff trying to push people away from housing. Well, now it can be used to meet those needs, which are AFFH means. I have made the joke in this year since I've been out. It's been very enjoyable to go to a lot of affordable housing conferences and see these best practices related to affordable housing, which I came up being reared as AFFH policies. The use of preference as an inclusionary tool is another way in which AFFH kind of undercurrent shows up on a good practice to be able to promote integration. And it comes with that principle that the federal dollars involved, if HUD's involved, that we're not simply there not to violate fair housing laws. Right? We're not simply there. We're working to further the purpose of the promise of the Fair Housing Act. And so we're moving from this historical age of requirement into quasi-requirement preference of exclusion into the present day in which we're thinking about deploying them for inclusion. And that's the evolution of the preference. That's kind of really the exciting part for me, especially as someone, like I said, I came from an enforcement background. So for myself, I've always been scrutinizing these, thinking about exclusion. And so I'm taking that same lens, and hopefully, like this first part has showed you, now we have the foundational pieces that we're going to then employ to look specifically at how preferences existed and operated and how they were then employed and then how they could be employed to advance housing opportunities. And one thing I want to point out about when we think about preference, just to bring it back when we think about impact claims, is that when we're considering effect and we're considering and analyzing that, and this is just going to close out why I think that is a great concept to use, not as an obstacle, but as a way to validate a preference, is that discriminatory effect, disparate impact claims, they don't exist to remove unnecessary barriers, they exist only to remove those artificial, those unnecessary barriers. They don't exist for the displacement of valid policies. And so if a valid policy exists to be able to advance opportunity, I think that's the evolution of the preference, to advance opportunity, then we have this lever to be able to use preferences and understand preferences and to be able to walk that line to assess how that preference can operate to achieve our program ends and to be able to do it non-discriminatorily. So with that, we're going to take a 5-minute break. Leah, can I have you?
Yes, yeah, that's correct.
So 5-minute break, and then we're going to get a little bit more deep in the weeds with our foundational knowledge on how to look at these preferences more deeply in their evolution. So see you in 5.
I started a countdown timer as well in the corner to help with that.
Okay, let's get into it. So preferences, the first part, our foundational part one. Does anyone have any questions? You could raise your hand or put them in the chat.
Looks like we have a question from Wes.
Thank you. Can you hear me okay?
We can.
Okay, James. When you put up the slide for disparate impact framework, let's apply that to workforce housing. That wasn't one of the preference programs on your list, but I think you'd agree with me. Those are popping up everywhere. Do you think workforce preferences for jurisdictions, locales who are trying to give preferential placement to their workers in their community, do you think that could potentially have disparate impact issues?
Yes, that's foreshadowing.
Oh, then table it.
But yes, we're going to get into that. We're going to talk about the evolution, and we're really going to try to analyze situations that we're seeing today. Residency preference is going to be our foundation because that's where we have the analytical preference on lawfulness. But they've evolved. Any other questions? Before we get in the weeds?
James, it looks like we had one come in through the Q&A feature that I must have not seen. Apologies for that. But it was, so if the purpose is to include a protected class by prioritizing them for our program, is that okay?
Depends. One, when it comes to like race and national origin, we're all protected classes. But I think in this instance, say that you're looking to prioritize, say there's no, say, you know, like trying to think of a good example. I was going to do source of income, but maybe just think of your program for individuals with disabilities or homeless population or veterans. Generally speaking, you know, I think like a safer route per se, although we're going to get into some really challenging disability questions, but you still, the analytical framework's the same because a preference operates to exclude. You have to ensure that although you are allowing a preference, which is a protected class, this is kind of where the Fair Housing Act gets a little hairy with statements. There's a statements claim that talks about it's illegal to have a preference based on a protected class. It kind of gets a little bit more difficult to, you know, like, sorry, I was thinking about difficult to special purpose credit programs question. You still have to you have to go through the same analytical steps because it's a limitation policy, it's an exclusion policy. So that's the well-intentioned. We're trying to benefit. I assume that this question is not based off of race or national origin. We're trying to benefit this population, and they have identified disproportionate housing needs. How do we design a program to be able to target that population? That's the evolution that we've come to. Will I be speaking on special purpose credit programs today? It's not in the slide presentation. I would disagree with the present administration's policy on special purpose credit programs, but you know, obviously that's why I sit in the seat outside of the federal government. I think special purpose credit programs, essentially these are tools to be able to help traditionally disadvantaged populations, BIPOC populations have access to credit. So that is part of the Phi Beta Kappa probably analysis of different housing programs and eligibility requirements. So that's a little too deep of a dive for this one, but they were very valuable tools that were used. They were used in Colorado. And the present administration had made policy statements attacking their validity and compliance with fair housing laws. So they're a challenge right now. Okay, so let's get back into it. This section, depending on, although I have a fallback on the participation piece where I just keep talking. You just have to listen to me go through numerous number of hypotheticals over and over again. But this one, I'm thinking about an hour of material. Could be like 3 to 5 if you got going on some of the examples. There's a lot here. And reason why is that preference evolution. We started in affordable housing programs and public housing with residency requirements. Those evolved once requirements were struck down to residency preferences, local preferences, which might not always be local, and then to workforce or local employee preferences, which could come up in different ways. And then that evolution to now, and I think this might have been the one question in the Q&A, was Well, we're trying to identify a population of disproportionate housing needs, so a specific population, and provide preferences for them. Youth, as defined in different categories, 18 to 24, the elderly or seniors, and then disability and specific disabilities. And there's different levels of risks as we go through each of those subset of evolution of topics. So let's get some foundational knowledge. I know we were going to move on from foundational, but when we go through our examples, this is going to be really helpful. Like I said, preference assessment from a legal standpoint, from a legal framework, traditionally has been done on those local policies. So we mentioned requirement. In 1980, there's a housing authority in Alabama, city that predominantly white, predominantly like 92% white, I think it was. And it was called Chickasaw, the city of Chickasaw in Alabama. They had a housing authority. And so the housing authority decided that they were going to deploy a residency requirement on applicants to housing. The county that Chickasaw in was much more diverse. And so essentially that residence preference, which was operated as a requirement, a residency requirement, operated to exclude the white residents or the black applicants and in favor of the preference for the white applicants, even though it was a residency requirement. That goes back to kind of those beginning slides, just thinking about just a straight ahead view. Okay, we look like this. Remember, we're all protected classes, and then a number of us fit into those other protected classes. And then this requirement, this preference that operates as a requirement is going to exclude individuals. Also of a protected class. That's where you're going to have problems with segregative effect, discriminatory effect, and intent. The first case we have here, I talked about the different ways preferences come up into play. This is actually derived from a zoning scheme. Town of Huntington, it's in New York. This is in the 80s. And so they had a zoning scheme in which the minority part of town, the part of town that was predominantly black, was a small area which they labeled an urban renewal area. And that was the only place that multifamily housing could be built, and affordable multifamily housing and publicly supported multifamily housing. So this is perpetuating segregation. So it's the use of a local policy decision that led to this preference, because the zoning scheme and the refusal to rezone for other multifamily throughout Huntington, it perpetuated racial segregation. It confined affordable housing to the minority areas. And that's a case I quoted in the beginning. It's talking about a policy that's meant to exclude. So this is a different way that preferences came up. This is a very good way to think about them, because what that case led to is being used in a number of lower court decisions across the country, which one of the more famous ones is this one in Massachusetts that had to do specifically with preferences and publicly supported programs, either publicly supported housing, or in the instance of these next two examples, the administration of Section 8. And Aberdeen Housing Authority and other housing authorities, they're outside of Boston. And so several of the housing authorities, they're all in predominantly white suburbs, and they adopted identical residency preferences for their Section 8 program and the administration of their waiting list. A group of women and a fair housing organization came out and argued that those preferences create a discriminatory effect because the demographics of the suburbs were predominantly white, whereas the urban core of Boston was much more diverse. So those residency preferences were struck down because they're disproportionately benefiting white residents or minorities, and thus there have disparate impact. Again, this is a race residency preference case, but very good to help analytically go through these other evolution of these preferences. The next case, Buffalo and Erie County, is kind of the inverse of that Alabama case, but it is something that's common across the country in different ways still to this day. This is a case from, it's like early 90s, so I didn't write that down. But this is a case outside of Buffalo and Erie County. There was a number of consortium communities that were administering housing choice vouchers, Section 8 vouchers. And so they created a preference that excluded the residents of Buffalo. So Buffalo, more diverse population-wise, suburbs, predominantly white. And so that created a donut problem in which there was a preference area that was excluding individuals who lived in the urban core. When I mentioned that, I call this a donut problem because it's very consistent. HUD's got a regulation that talks about a residency preference a county or a municipality is used as a residency preference area. An area smaller than a county or municipality may not be used as a residency preference area. What HUD has not articulated well over the course of time was that what has occurred, and this is an example of it, I don't know if they cited this specifically in the case, but counties were administering preferences, and the county would be predominantly white. So they say our residency area is our county, but then they would exclude municipalities in the county. And so in other words, they would say, well, we can do that because we're a collection of municipalities and it can't be smaller municipality. So we're a collection of municipalities. And so this donut problem and residency preferences come up, and I know actually still exists in different areas of the country in which preferences for publicly supported housing and housing choice voucher programs operate to provide preference to individuals in the donut county core as opposed to the urban center. And that is just another good way to think about how preferences can be deployed on the local residency preference level to just set us up to get to the more difficult question of how do we deal with these new preferences that we're seeing? Live work or live and work. I think the first part I said live work is when I started seeing live/work. They were usually live and work. And that generally just operates like a local residency preference. So that to Wes's question, that's going to be the analysis. We're looking at a residency preference. We have a means to look at that. Actually, talking about the next step. But live and work creates a problem in the sense that you're creating a residency preference because you don't have to. You're not just working in the area, but you're living there too. So you're operating a residency preference. Oftentimes with these, the justification is moved from, hey, we're not just supporting people who live here, we're supporting people who work here. We want to support our workforce. That sounds legitimate, but when you attach the live and work, you're really operating a local residency preference. To the second piece, employee, work, and workforce. These are employment-based preferences. Again, these are put in place. I think these are more the evolution to well-intentioned preference. They're no longer residency-based specifically for place-based, and therefore we know we have a really high risk for perpetuation of segregation. But we're thinking workouts already. We're looking at the priority for people who work locally. We're thinking about our essential workforce, our teachers, our healthcare employees, our public safety employees, our municipal employees who may not be able to find affordable housing within the boundaries of the locality. So we're trying to balance it. Like jobs to housing and add that economic function, having them in our city where we're paying them to work in our city, that's going to add a driver of economy for us and supporting us. The same assessment though, we want to think about who's in the workforce, who's going to get the benefit of the preference, and who's being excluded. And again, another part about these preferences is, again, we're still subject to reasonable accommodations. So then we also see the live-work hybrid. So that's really hybrid. That's the opposite of, not the opposite, it's the evolution of the live and work. And I think where municipalities or housing authorities have come, well, that's really what we intend. We want live and work, or live or work. We don't want live, sorry. We want live or work. So we want to be able to allow people to reside in our city for multi-generations and support them. But we also want to be able to provide that benefit of employment, and just like the employment-based preference, bring people in. So it's broadening eligibility, and it does reduce risk. If you're thinking about live and then you have a broad workforce, that's going to reduce risk related to that, that legitimate, valid interest that you start with before you put in place a policy. But like all of these, if you have just a workforce, it depends. You can limit the work part of it to specific subsections of industry, and that population might mirror maybe the population in the municipality, as opposed to, especially if it's a suburb or exurb, maybe the urban core of the metropolitan area that it's located in. That is where the friction creates. That's the limit. Like I said, preferences, their limitations, their exclusions. So the greater the limitation, the greater exclusion, the higher risk. And then we have on here another evolution that has come into play, the community or place-based preferences. Community preferences, There was some discussion of this in Denver years ago, but really where community preferences have come up, you're thinking about, okay, you have a large, diverse, from the top level view, large, diverse urban city. 500,000 plus, million plus, large. And then you have areas that are being subject to gentrification. And so to combat that, you put in place anti-displacement strategies and you create community preferences. And those preferences are almost smaller. They're small. Well, they are. They're smaller geographical areas. They might be census groups. They might be neighborhoods. They might be districts. They might be political districts. They might be revitalization areas. But they're smaller place-based areas. And the goal is anti-displacement, but they come still with a lot of scrutiny because it's not as easy as helping people maintain for anti-displacement and gentrification, because segregation is now working in many different ways. So community preferences, they come into place, and sometimes they don't. They come from more hypothetical or speculative, or maybe even just, I guess it's better for them, altruistic ways in which they need to maintain that cultural core. But at the same time, they can work to perpetuate discrimination. And sometimes it can be designed specifically as intentional discrimination tools. So they have been, we'll get into this a little bit deeper in a few minutes, but they have been the subject of attacks in New York City and San Francisco. I know if we're working in Colorado and the Denver metropolitan area, we're like, well, we don't live in San Francisco or New York. And obviously, if you've been to those areas, you know the cultural components of different sections of the city, and very stark across different races and different national origins. And so the challenge has been to address displacement while also complying with civil rights laws. So how do you use that as an inclusionary tool when you're almost deploying it like a local residency preference was when they were very problematic 20, 30 years ago? So we look at these different types, and again, we're still going to put them through that. I love using the idea of just putting them through a machine. So just like the preference is a rule that we're putting our applicants through as a machine, we're still going to put this through our machine of analysis. They come in different ways, but they can be, if we're aware of that, we understand the risks behind them, that's how they can be designed and structured to meet that local need while also avoiding the discriminatory effect and the perpetuation of segregation. And again, segregation works across classes. When we get into disability, remember, individuals with disabilities, institutionalization is segregation. And so when you employ different target methods and preference methods to try to incorporate integration into your housing communities, into your programs, that's trying to integrate, but then it comes with the same kind of difficulty in deployment. So scenario preparation, again, I love repeating things over and over again because it puts in your head how we want to think about these scenarios. Disparate treatment, that's our discriminatory intent. Does the preference intentionally treat an individual or class of individuals differently? Is it because of a protected class? Discriminatory effect. Identify the protected class, identify the policy, compare populations. We're thinking about greater harm for our impact, because the way the test goes, you go greater harm, you go statistical disparity, those chi-squared, Fisher exact, these statistician type terms and these scientific methodologies for showing something statistically significant. Let's just think about greater harm. And then, is this because of the preference? So to Wes's question, we're going to do a workforce housing preference. So Education City adopts a preference for teachers working in the city. Education City is a suburb of Metropolis. The preference is going to operate like this. It's going to be for public school teachers that are employed within the city, and it's going to reserve 20% of affordable, we'll put affordable in quotes because you'll see the next bullet point, that are going to be reserved for those teachers. It applies to new light tech developments, and it applies to developments receiving city subsidy. So no federal financial assistance. And then with both of those, right, we're going to think about different ranges of AMI. Otherwise, just an open lottery system. And some of their justification is they say, in Education City, we have a high turnover of teachers in local schools. And the teachers cite high commute times. So we have a preference. It's not, they're trying to design it to keep what they say. They need to avoid the high turnover in local schools. And then our teachers, I just keep that in fact, they skew younger, so they're more living locally towards metropolis, and that creates these high commute times. And so there's a reason why we want to keep these school teachers. We talked about workforce. What is one of the probably a first area to think of this preference and whether it could be problematic? So what I think about, of course, I drafted this, right, is I purposely put teachers. And teachers, this isn't workforce. The less riskier one is going to be the employment-based workforce that looks for more of a broader essential worker, municipal employees, public school, municipal employees, public safety. That's going to be broader. So you're going to have a population that potentially is going to be different. Now, what if I told you that Education City, like I said, it's a suburb. Let's say it's a much smaller suburb, like 75,000 people, and it's 72% white, 28% BIPOC. The median income in Education City is $102,000. Whereas Metropolis, they have a population of 122 million, and then their statistics are inverse. Their median income is 50,000, and they're 28% white, 72% BIPOC. Teacher preference. What's the first thing? Again, we're thinking about that limitation, right? Now we have a smaller statistical group. What does Education Population City look like compared to the teacher population? So if we go back to we're going to go back a lot. Hopefully this isn't like strobe light effect here. So identify our protected classes. So protected classes, I'm thinking based on demographics, the first place my brain's going is race. So I'm thinking about population in Education City, it's predominantly white. Metropolis is like the flip of it. And my first protected classes is race and national origin. So I'm thinking about that race and national origin piece. And I'm thinking of what's the population, what's the demographics of the teachers that are working in Education City. So if they're developing this policy and if it was just a straight preference, and we're thinking, let's say the teachers do look like Education City. Well, that might be excluding individuals based on the rational origin. We could see greater harm for these affordable housing programs, and Education City is an area of opportunity. They have a median income of $102,000. And talk about high commute times. There's probably people in this affluent community who work there who would love to have an affordable housing there, but then have to go back to Metropolis City and do that commute twice a day. And now they can't reside there and they have greater harm. And let's say they are of a different race, and let's say they are BIPOC. Now all of a sudden you're thinking this is greater harm. This could be an effect situation. But what if the teacher workforce was more reflective of something of a more diverse workforce? So if the teacher workforce reflected a more diverse workforce, and Education City is this high opportunity suburb, and they're trying to maintain, we're back on the line of thinking about that broader workforce. This is we're removing risk. On the race and national origin side, we're creating opportunity for greater diversity and integration in the school system and maintaining people in our community. It's going to come down to the demographics. So that another way that this is somewhat limiting to be able to limit risk is it's got a 20% level. So it's not a priority in which they go to the top of the list per se. So it's not a preference where if you're a teacher and you work in our public schools in the city, you go to the top of the list. That's what our preference is. That's how we're going to reorder access, is we're going to put you on the top of the list. That's the greatest risk. This is trying to be more thoughtful or intentional, or at least the person who drafted it was, in thinking about how could we potentially limit risk and think about the different ways that the preference could be in place to deploy those ends. Because they're trying to meet that local workforce need. They have a service delivery for their schools. They have this limited share, so they're really nearly tying this down. It doesn't dominate the number of units they're using, but then it gets to another problem, which if there is a race disparity, it is a national origin disparity, what about those needs? What if, I mentioned Education City is $75,000 to $100,000. Let's say they're a CDBG entitlement jurisdiction. Let's say they've done a consolidated plan and they don't even identify disproportionate needs for workforce housing. They're identifying disproportionate needs maybe for seniors and the elderly, individuals with disabilities. That now could cut against it. And now we have the issue of individuals with disabilities coming into play. So there's many ways that this could go. But I think Education City is saying we've narrowly tailored this. We put this 20%. We're looking at our teachers. We want to keep them in this community. So we have this legitimate documented need. We've done the research. We have the studies. We've got the turnover rates in our teacher workforce. And then we have the demographics of our workforce. So they're going to argue teachers are essential and they're more diverse. They add more integration, more integrated community to us. But they're being priced out by our area of opportunity and the more affluence that Education City has. But it's still complicating that Metropolis looks disproportionately different than the residents of Education City. And so that's going to mean that in preparation for and in deployment of, there needs to be an understanding of how these come up, including the last one, the but for, like you rate as preference. And then when I say how these come up, like you're talking about the expected, you're talking about the populations, talking about populations who are going to be affected to analyze. And then you're also, the periodic review, if it does get deployed, is understanding who's going to get access to the, and if it is it really in 20% reserve for, what if it's above that? And what if it continues to look like Education City's demographics and not Metropolis? These are all just red flags. In other words, there's no answers here because everything is methodology and putting it through the assessment and analysis. Then I have another twist here. Does location and demographics of education matter, or city matter? Well, we mentioned demographics matter. Does location matter? Of course it does. To our assessment, to go back and be able to identify protected class, identify the policy, compare populations, identify greater harm, and then try to tie that to as a causation to the preference, we're going to have to understand what the populations look like and what location means. They mentioned commute times, but commute times might, like I said, if the demographics of the workforce to be given the preference reflect Education City, commute times could be pretextual. Commute times could be put in place to just point out the distance. I don't remember where this municipality, this comes from a 2015 affirmative furthering for housing presentation. I have 30 maps to try. I have no idea. What I liked about this one, and I try to expand it, so I really don't remember where it is. It's not in Region 8, just so you know, this is a national presentation, is that there's the darker areas are more urban areas. There's correlation, there's dot density for population groups, but there's no darker areas are the size of the population density totality. So, you know, if Metropolis is down here and Education City's up here, you know, maybe that commute time is more of a buffer. It's trying to keep our own in. So that kind of comes to an intent question. And then another way to look at this, to flip it, when I think about location, which I could kind of use this map for, is what if you flipped it? What if Education City was the MSA's largest and it was the most diversity and they're trying to create this preference? Well, if they're more diverse, then likelihood that's going to reduce risk again. Workforce housing preferences in more diverse locales are going to have reduced risk. Again, we still need to put through that analytical framework, but they're going to be reduced risk. And when you look at these, where these preferences generally oftentimes come up, they do come up outside of that urban core. So they come up in the suburbs, those ones in the AFFH universe, think about high opportunity areas with stronger schools. And so that is going to cause us to go through this methodology and think about the different ways in which something could pop up there. But again, we're trying to frame this back into it and thinking Okay, there's a local need, service delivery. That's our justification. Let's think about what the protected classes are. Let's compare the populations. We have the preference group. So we have the teachers, the teacher workforce, and then we have the populations of those who potentially would be eligible but be excluded. And that's going to really come down to what that map looks like. And I pull up the map is because, like I said, you don't have to be a statistician to understand greater harm. You can pull up a map and you can understand, maybe you don't have to, you can pull up a table too, and or if you live in a large metropolitan area, you probably understand what the demographics are to begin with, to understanding that population group you're serving. Is that exclusion going to be problematic? Is it going to be lawful? Is it going to pass that test? And again, it starts with intent. Why teachers? Why teachers only? Do teachers look like the more predominantly white area? Are they look like our city? We want to keep them there? Or are teachers more diverse? So we're not just supporting the workforce, we're also bringing in a more diverse subset of population into our community. So we talked about protected class lists. I'm thinking race, national origin. We talked about the justifications. Another thing that we didn't put in there because it's the last, because I'm going to get there, is the justification piece. What do they rely on? Traditionally, from a HUD perspective, when we looked at publicly supported housing programs and we looked at preferences and we looked at what was a valid interest, we always looked like at the applicable, we looked at housing needs assessments and local comp plans and how they discuss workforce housing. You probably are not getting granular to the effect which you're identifying teachers, right? It's probably more housing stability for public service employees, teachers, healthcare workers, promote workforce stability. This could be in a comprehensive plan as well. So there could be more through essential workers or workforce housing, which would be more broader. And that's kind of the risk here. So teachers are not a protected class. However, each teacher is going to be a member of a protected class. And so what that looks like, again, we're thinking about the protected class risk, probably race, color, and national origin. And then that's going to pull on the demographics of the area, the location, and the different ways in which it's deployed, and then understand those justifications. Are those justifications just hypothetical? Did they pull them out of actual reason? Are they actually disproportionate housing needs? Is it tied to a disproportionate housing need? That's those documentation, those studies, those assessments, those analysis, that's the undergirding for the legitimate interest because of it. I think what also reduces risk is going to be if the workforce is more economically diverse. It's still tied to employment. It's still tied to geography. So if you're going through the steps, you're analytically just putting things in those boxes. But at the same time, the population groups are going to be different. And the integration piece and the inclusion piece is going to be different. It's going to keep reducing risk. And that broader group then defends against the arbitrariness. I think in a way, this teachers is very limiting. And again, I think it's going to have a challenge being tied into some legitimate justifications. But if you're going to use geographic as a proxy and you're using employment, you probably want to tie it in as broadly and think about a way to have it to better achieve your outcome. Got a light tech comment. I can answer the John Pogan on a specific employee. In other words, Catherine's telling me bad example because there could be light tech units in that building and can't do that. Catherine, just think about the city subsidy side then. So the purpose of the policy, we have some supporting facts to support it. There's still that disability issue though. The disability issue still sits out there and that's going to be a little bit more nuanced here. As we think about the debrief, again, I think a combination, the availability of combination to rule, policy, or practice. When we think about that kind of makes us look at disability accommodation a different way. So you think about disability accommodation, I mentioned anybody can request an accommodation. It's a rule, policy, or practice. It's whether that accommodation is necessary. It's necessary because of disability-related need. That might be someone who has reduced hours to qualify if, like, say they had an hour level, like you're not just a teacher, but you had some sort of hour level, or you're not just with a specific area of employment. There's teachers by the public schools. We've run afoul of light tech rules, but more of just like a category of employment. See, like there's hours attached to it. The disability accommodation can be as simple as somebody, I work 20-hour work weeks and I can't meet the 30-hour work week, and that could give them access to the program. But sometimes more nuanced question, which is really going to be individually specific. If you have this workforce housing, again, because accommodations, and I can take this out, case by case basis. So accommodations on a workforce housing one, if it's just a workforce housing, work in that area, that municipality, that locality, then you're looking at that accommodation a little bit differently, and it might change the reasonableness, because you might be looking at whether or not this is undue financial and administrative burden, or if it fundamentally is the nature of the program that could come into play. So it's a much tougher analysis on the necessary piece and the reasonableness piece for these broader preferences. But we know that workforce is not necessarily neutral. We have to think about the race and national origin impact. And then we went through a number of different ways in which it could be wrong, like how everything flips on their head. So things could flip on its head if all of a sudden this demographics and the stats, first of all, starting with the intent, we want to help our teachers, because our teachers are more demographically aligned with the communities, whereas our municipal employees and our public service employees, they're more diverse. That could be an intent problem. So you have an intent problem potentially. But then, and so we flip that could be an issue. Also, the cases of wrong is as you go through and you start comparing population groups and you start seeing different impacts and effects, which could mean you do bullet point 4. You're thinking about alternatives. Maybe you're changing percentages. Maybe you're thinking maybe you're thinking school district, not just locality schools, or maybe not just, a larger geographical area, and you're changing maybe how that is employed to be able to have some, be able to assess priority, to be able to adapt and pivot to ensure that the demographics do not run afoul, showing some protected class group is being impacted to a greater harm. Do rules need to be challenged by someone with standing, or is there any form of regulatory enforcement? What about non-federally funded developments? So standing legal principle, you've been injured by the act that you claiming would be in violation of the law. Generally speaking, I do not expect HUD to bring many disparate impact cases. No, they're not going to bring any disparate impact cases, at least in the short term, potentially on DEI, but we'll see about that. So do you have to have standing to make challenge in court? Yes. But if you live in the community, you're going to have standing. So the fair housing laws are broad and inclusive statutes. And so the Fair Housing Act, as it's interpreted, which how CADA will be interpreted too, those fair housing laws are broad and inclusive. So standing is going to be very standing to be able to identify that you've been injured by an alleged discriminatory act. If you live in a community that has a preference, or if you're seeking to reside in a community that employs a preference, or you would be among the group excluded from being able to avail yourself of that preference, you're likely going to be able to show standing. What about non-federally funded developments? Non-federally funded developments, again, as a regulatory body, I don't necessarily, there's different ways. From an enforcement side, say like in your FHA program, theoretically you have to comply with the MAP guide for HUD. I know it's kind of abstract here, but there's different ways in which program rules could be deployed from an audit standpoint. But that's probably where you're going to reside as far as regulatory enforcement. So preferences now have evolved to intentional and for integration. Preferences are intended for diverse and integrated housing. They still maintain risks, as we went through the scenarios on teachers, or just say like an employment base. So the justification, we know, has to be evidence-based. It can't be hypothetical, it can't be speculative, because the legal standards remain. Disparate impact is a legal standard. At the same time, it's that framework. We're going to use that. You're going to have these slides. You're going to be able to pull that slide out. You're going to be able to think about the slides that walk through, identify the protected class, the policy, the comparison, and to be able to do that, the greater harm, and then the causation. So those standards apply, but it can show us the way. And part of that way is also, it tells us that if we're concerned about a harm, we can evaluate less discriminatory or less limiting alternatives. Preferences must make reasonable accommodation, but must be for disability-related need. Where I've seen problems over the years is the unavailability to make the reasonable accommodation. That denial puts in place a denial before you get to the necessary and the need, And that creates obviously problems. It creates problems with litigations. It creates problems in administrative enforcement. And disability claim, that is a disparate treatment claim. So someone could go to CCRD, someone could go to HUD, someone could go to state and local agencies and make that claim without having to argue a discriminatory effect claim. And like I said, good intentions are not always enough. And that gets us to a more deeper dive on anti-displacement preferences, which we touched upon earlier. These are neighborhood preservation tools. We're trying to keep the people who reside in our community. These anti-displacement, I think probably everybody on this knows, is not just something that exists in New York and San Francisco. Anti-displacement policies are in place in the best practices in the speaking terminology of present-day affordable housing across the country, not just in urban cores, but in suburban areas and in mid to large-sized cities alike. So anti-displacement preferences, they keep on coming up. They're not just in San Francisco and New York, even though that's where we have seen litigation and regulatory problems with them. And they're put in the guise of neighborhood preservation. We want to address gentrification. Gentrification creates segregated suburbs. So segregated you move segregation from a historical area that has historical demographics of a group based of a disproportionate number of Blacks, Latinos, Asians, something that's got like cultural significance, that neighborhood, and then you get segregated living patterns outside of that urban area. And there's a lot of community buy-in. There's stability. They look at stability, look at the political buy-in. All the cases in New York and San Francisco and there's cases in Portland, they really had a buy-in from the local elected officials. But it still risks perpetuating segregation, and it has a lot of legal vulnerability because it's all about policy design. So though it's a tool, they require scale and targeting and use of data to be able to understand how it will be operated and the legality of it. And that goes back to how do you reduce harm? Anti-displacement measures can be inclusionary tools, but you want to use them, even though it's emotionally intuitive, to use them to that they're narrow, they're blended, and they achieve levels of displacement in a way that doesn't affect or not confront the violation with civil rights laws. But they are by their nature, their policies that allow who gets to stay. And so those policies, they might make projects possible, but potentially then they could show up coming back later. And that's the risk. That's the periodic assessment piece of any policy, is to understand what that segregation is, understand what that discrimination risk is. At the back end of this slide deck, there's going to be a link to an article that talks about San Francisco going through community preferences. There's going to be a number of community preferences article because I think they have a really good analysis about how to look at these when we're concerned about displacement of the residents within the communities that we reside. So you have these areas, obviously, the one article is about San Francisco. San Francisco started with an affirmative fair housing marketing plan, by the way. But how they find solutions, they can teach us lessons to understand what the problem is. Maybe the demographics are not going to be statistically disproportionately stark as what we'll see in Colorado. But at the same time, when we think about greater harm and trying to address displacement within our cities, our suburbs, our municipalities, our counties, that's going to come up. Youth-based classification. I got a question here. I got to come back to this question. I'll tag this question. We gotta get the rest of the areas. Age-based classifications. This is where I bring up the Age Discrimination Act and federal financial assistance. Age Discrimination Act cases, they're few and far between. I think there's probably a lot of people on this call that know about using federal financial assistance programs and be able to do some youth targeting. But I don't know if you understand how that comes in confrontation with the Age Discrimination Act. So there's programs across the country which are federally financed about youth transitioning from foster care, homeless youth, and they use an age-based classification as their preference, as their prioritization. They use those preferences to be able to operate the program. It might be more broad than that, but anyway, there is youth targeted projects. And so these can come up as age-based preferences. And this will help us be instructive a little bit too when we think about how we might think about senior housing as well. So if you have a project, there's programs that allow you to, despite that Age Discrimination Act and that prohibition on age discrimination, to be able to operate in a manner that complies with civil rights laws. A lot of that has to do with the design of the programs. So programs can be designed that you're really looking at a larger system, and the age classification targets a population for entry into that system. Again, these are the nuances in which preferences don't need to be scary, but they can be developed and they can narrow to be permissible. The Age Discrimination Act gets very interesting because I think it's another good way. One, if you're operating any age-based program that's a class of individuals, it might tie to any number of disproportionate housing needs in other ways, homelessness, disability, any number of veterans, any type of substantive group that they're a subset of a larger population. Then you're able to look at the exceptions to the Age Discrimination Act. I had an internal HUD joke that I've never met an age classification case that violated the Age Discrimination Act, but it's very instructive too to understand why that preference, why that targeting, why that priority might be necessary for the normal operations, because necessary for the normal operation of a program is an exception to the Age Discrimination Act. I've paraphrased the test to think about this. If you have an age classification, think about, is age a proxy for real need? Is that essential to the program? Is age a reasonable way to identify that group? And is there a practical alternative? And these are factors to be able to qualify for the exception. So age in youth programs, in elderly programs, well, age itself is not the proxy, just another characteristic. And then you also design models in which those individuals are going to come joints. That's the integrative piece. And also then you're trying to align different ways in which to identify that group and use that age classification as a reasonable measure to understand the need and the need to serve the purposes of the program. And then identifying that there's really not another way to do it. You have this vulnerable subset of group, and one way to reasonably identify that group is by age. And 18 to 24 and programs for the seniors, oftentimes they fall in that group in the administration of the program when tied to other areas. Right? They're not staying in isolation of only housing individuals who are 20 and under, or 18 to 20, or some stark age classification. It represents the nuance of looking how we can design something that's part of a larger program. And even though this is specific to youth programs, it's very helpful just generally, I think, if you want to pull this out to think about, we're going to deploy a preference, not just thinking about the Age Discrimination Act, but just maybe take some lessons from that and think, how could we understand if this is necessary for our operation of our program? So this is the case is the Age Discrimination Act is providing an exception for a certain number of youth age-based classifications, but at the same time providing some instruction for us on how to think about the normal operation of programs when preferences are employed. Okay, now this is a really difficult scenario, so we'll probably spend the rest of the time of it. I'll try to keep 5 minutes at the end. There's a senior housing one scenario at the end. Maybe I'll get to the senior housing one is not necessarily a preference itself, it's how senior housing could be masked as a preference. I'll say that. Senior housing, but maybe we can touch about, I can touch upon that in 30 seconds. So let's draw this back. Specific disabilities, well-intentioned, good intention. Isn't this a good idea? We're going to have a housing development and it provides a preference for households with neurological impairments. Common models across the country. Located in a large city in a metropolitan statistical area, part of the development to make it work, there's going to be supportive services at the property. The development's done in conjunction with partner agencies. Again, these models are popping up all over the country. They have an AMI level, but they're also going to prioritize individuals experiencing chronic homelessness and disability-related barriers. So, flagging some things. We have this preference. How is that neurological impairment defined? Because this next slide, which you got a sneak peek on, is going to come into play. Also, how is the development going to there?
Yeah, you cut out for just a second, James, if you want to just go back just a few sentences.
Okay, I lost my chat guy. Okay, can you still see the screen?
Yes.
Let's get on the roll here. Just tell me when to end. So, specific disability. So, again, is that a broader set of individuals with disabilities? Are all persons with disabilities able to apply to property? How is it going to be? How is it going to be designed? Is it designed to support individuals with different types of neurological impairments, or is it designed specifically with specific types of diagnosed impairments? Diagnosed impairments is a problem as we see. And then how is that structure of entry, that coordinated entry or the referral structure going to be able to operate? How are they going to prioritize eligibility? Is there going to be a disability eligibility as opposed to a specific disability eligibility? And here the reason why I bring this up is because it's very well intentioned. And there's two components here. There is, if there's no federal funding in this is a wonderful model to be able to provide housing in which you can drill down to individuals with different types of disabilities. But if you have any HUD dollars in there, this is a challenge of the 504 regulations. HUD regulations implementing 504 restrict when participation in a federally assisted program or activity can be limited to individuals with disabilities or individuals with specific disabilities. Limiting participation, I'm going to read this because this is important. Limiting participation in programs or activities for persons with specific disabilities is permitted, limited, only when I should say only because it's pretty much kind of that, including when there's express federal statutory authority to do so. When you see programs designed for individuals with specific disabilities, they're attached to federal statutory programs or regulatory policy. Without that authority, restricting access on specific disability excludes, and this has been a line that's HUD used for years, and it's still girded in 504 regs. They discriminate against individuals with other types of disabilities who are otherwise qualified to participate or benefit from the program activity, which all is to show is that you have a well-intentioned plan. And then you design a preference to provide preference to a group of individuals who are a subset of individual with disabilities. That's going to create risk if the federal funding's there. Like I said, if the Fair Housing Act's there, you're back in our old assessment. You're putting things and you're looking at the population served, but you're working towards to create an integrative community. The community is going to be important too. The community design from a Fair Housing Act side is going to be important to make sure. The reason why it's important is because there's a difference between essentially quasi-institutionalizing individuals, which is a Olmsted concept, which is federal financial assistance, but that quasi-institutionalization, that segregation, that steering, versus a mixed model community where you have a set aside or a small number of units available. Well, housing in the whole community is available to anybody, individuals with disabilities. Say like we're doing a Fair Housing Act, you could design a set aside that's purpose is to create integration, and it's meant to not discriminate. Disability is a protected class, privately, Fair Housing Act, where discrimination against someone who's not disabled, that's not violative of not disabled is not a protected class group. So our protected class group, then we're designing this to serve it. Preference for specific impairment, federal financial assistance. Now we're creating problems. We're creating problems of targeting, we're creating problems of steering, we're creating problems of how that preference operates to exclude. So financing here is very problematic because even though you have Olmsted never got to Olmsted has not yet got to that point of integration. I think the intuitive way to look at housing for individuals with specific types of disabilities is, well, there's this Olmsted mandate. That's for integration. How can we apply our public services and our public responsibilities to create more integrated housing? But that's design and marketing and the way the project looks. There's an ability to per se do it from services and voluntary services, which is this next slide. I got off the rails here, so I'm going really quickly. But you'll have my contact information if you want to keep talking about this stuff. Because specific disabilities to me is like, this needs deeper dive. There's not a lot of discussion here. We're stuck with some regulations. And from the HUD side, we have public housing regulations. With preferences, HUD programs that can adopt a preference for admission in HCV, and this applies to, this is a general line used and drawn back in handbooks and notices for people with specific disabilities. But PVV points out, and I think this comes to, and HOTMA, someone can correct me if I'm wrong here, you can give a preference for people who qualify for voluntary services, including disability-specific services. But that same regulation says it doesn't impact the prohibition on granting preferences for persons with specific disabilities. So how do you address that? Well, it can be lawful. In the Fair Housing Act, it can be lawful. You can design it so it's open to all income eligible persons with disabilities, but you could design to have targeted set-asides or targeted outreach and referral partnerships and different services attached to be able to operate this justified and to be able to serve individual disabilities and to be able to provide services and serve individuals to integrate them into a non-institutionalized, a integrative community setting to ensure that it's lawful. The sticking point comes with the federal financial assistance and its applicability to 504 and the ADA. But then what do we do with this integration mandate? What do we do with that? That's kind of a tough thing to think about from the Olmsted side. We're thinking, well, we have this integration mandate. How does that come back to being able to ensure we meet our federal financial assistance obligations? And I think there is some light in that with design and voluntary services at HOTMA and marketing, and to steal a line from like HOPA and Housing for Older People, how you hold yourself out to the community. Is this a property for all, which is partnering with a referral agency and partnering with voluntary services and has a design that would market itself and appeal to targeted individuals? This is a way that it could potentially work, meet its civil rights obligations, but it's really risky. It has to be properly designed with a lot of discipline with it and a lot of cross checks to ensure that there's it's approached in a non-discriminatory way. The classic bad problem is we have this design, we have 50 units, they're all accessible, it's a redevelopment, we have individuals with wheelchairs, but we're going to displace them, they can't stay here anymore. That's a problem because we want to serve a specific disability population. That's a huge problem. The more nuanced way, which I don't have a great answer to, there's projects that have levels, you know, I think the lower risk scales like publicly supported housing, but have federal financial assistance in different means in which they're designed in which nothing's required. Everyone, it's open to everybody, but there are design purposes, there are structures related to partners and entry, and as well as referral services to be able to attract and create an integrated population. Because even with those well-designed projects, the key is avoiding the segregation, the steering, and the clustering. What do I got? I got 2 minutes. Can you still hear me? Oh, yeah.
Yes, you're all good.
All right. So real quickly, in 1 minute, age-based classifications, because I put this in here at the last minute because I've been getting a lot of questions from developers who are considering trying to find a way to have set-asides for elderly, either 55 plus, 62 plus, in affordable housing developments. They not intending to discriminate based on familial status, trying to steal from models which are going across the country, intergenerational communities for seniors and families. And they want to consider, should they be looking at different funding streams from the federal side? And I think every one of them have been multiple buildings. Most of them have been multiple buildings. But think about, like, let's say you have a design, multiple buildings. It's got 2 multifamily buildings. It's got townhomes, shared amenities, garden, green space. So the interest is in this intergenerational model, but how do we ensure the seniors? Is age a protected class? Well, it is if you get federal financial assistance, but we went through those exceptions. Now, if you don't have federal financial assistance, say you don't have federal financial assistance, is age a protected class? That could change the analysis. But another way this gets caught up is that in design and conception, people are thinking, well, what about like HOPA? Could we do a HOPA model and have a building that's HOPA or units that are HOPA? The fallback is like maybe a building that's HOPA. That's where that description piece comes in. So HOPA doesn't allow for dual purpose housing. So if you have HOPA and you're availing yourself of the female status discrimination, you can't operate in the same community. Another thing about there with federal financial assistance, the questions come up, can we place PBVs in a property and maintain HOPA? HUD regs define family to include children. So you couldn't put PBVs and reserve them for 62 and older. So all these different ways come up. There's a way to make the intergenerational model work. There's some great models out there, but it really is going to come up to the role of financing and application, and then how you design this. So to close out, let's talk about some quick implementation, Rick. Remember, speculative and hypothetical is no good. Data it alone does not justify the need for preference rules. You need data and information, but you need those assessments, the studies, those sources to be able to tie back. So the demographics in and of itself is not helpful. You're going to have to justify the preference rules through more descriptive and more established means. Worry about overbroad application. These are all about analyzing who's selected and who is not selected or who is excluded. Rigid application, very absolute preferences carry a lot of high risk. Not allowing and articulating that accommodations will be assessed and individuals can make them requests. That's problem. No periodic reviews. That's going to be problematic as well. So when you're thinking about risk, think about all these different ways in which it comes up. Make sure you have a justification for why those rules are in place. They're established in not just numbers and people, but also in local and regional housing needs. Stay disciplined. The preference is about the objective. You start with intent, you start with impact. You're thinking about effect in the beginning, in the middle, and throughout. Understand where a preference adds to a link in disparity. Built-in adaptability. That's the reassessment. That's the reassessment. You're always reassessing it. And to that, less discriminatory alternatives. There's a lot there about designing for all when you're already thinking about that third part. Okay, there is effect. What could there be, if we do have a valid interest, could there be less limiting alternatives that we could use? Affirmative marketing and outreach are incredibly powerful for achieving the ends, leveraging those partnerships that you're trying to achieve, that perhaps a preference it stands in the same way, so it might right size it and then might right size the preference in of itself. Different ways to look at strategies to design that preference so it's not just one do-it-all preference. And look across the country for proven models. There's models out there on the things we talked about today. There's not a lot of litigation or case law that gives us that legal assessment to understand why it's lawful. But if you think about this from the perspective of understanding where you sit from intent and walking through that framework on effect, you're going to be able to go to that next stage of understanding the beginning, the middle, and throughout to be able to assess how this preference is going to operate and who is impacted from it and what are the outcomes achieved. So I left 1 minute for questions. But you'll get the slide deck. This is my contact information. I'll also be at Colorado NARO, and we have a booth or a table. So come ask me the preference questions. They're very intriguing. The second part of today, I think, like I said, once you get past the local residency preferences, it gets really abstract. There's some links here. I think these inclusionary discussions on community preferences is really helpful. It's really kind of the evolution. And you can apply some of those concepts of well-intentioned preferences to these number of ways in which workforce preferences evolved. And like I said, different ways to address other special needs populations. Like we didn't even get to other protected classes. Like there's veteran preferences out there, which are allowed. There are a number of different preferences for a number of special needs populations out there that could be deployed. But like any preference, it's a level of risk. Some are lower risk, some are higher risk. They all go through the same analytical framework.
Thanks, James. Do you want to answer some of those questions we got in the chat?
Yeah, could you read them for me?
Yeah, from Evan. What considerations would you make for source and income, in parentheses, as a protected class in Colorado in a workforce project? I can see how a person with a disability could make a reasonable accommodation request regarding a workforce, but what about someone without a disability who otherwise passes the tenant selection process and is able to pay the rent? Let's say someone receiving survivor's benefits, living off investment income, etc.
Is that in the chat? I might need to read that one.
Yes, it is in the chat.
I see it. What considerations will you? Well, so that's the design. I think that comes in source of income. Again, this could be fact specific. So I guess in this scenario, we're saying our individual who has a source of income to be able to meet the qualification category. So like they have a voucher and perhaps they don't meet that workforce requirement. Some of these could be Howie's workforce. That's the protected class. So it's a great way to think about it first. Let's think about first, what's the protected class that's impacted? Here, individual based on source of income. Okay, that's a state protected classes. How we're going to develop and design a workforce preference. You have the reasonable accommodation request like the person in the chat identified, but then you have this other source of income. So then comes to design. As those protected classes come up, you probably, if you're in Colorado, you want to be thinking about these workforce preferences from all those Colorado protected classes to make sure that they're not excluded and you have a means to be able to not discriminate on the basis of it. There is a little bit of a, I'm going to steal a word from terminology, a little bit of nexus here, even though it only applies to the reasonable accommodation request. I think this gets fact specific to kind of dive through how to design those. Because workforce housing, it might be not as simple as discriminating against somebody because of their source of income, but there could be design. You have to take that into account. That's a so non-answer, I understand, but it's really going to be fact specific. And the reason why I put those Colorado protected classes up there is to make sure that we're designing programs and understanding how those might impact them. And so it's tailored in a means that doesn't discriminate. And it's going to be, there's the effect part. But with source of income, there really could be a good argument on intent. I think I can read this now. On workforce requirements, I'm hearing you say that would be very difficult to justify in almost any suburb in Denver MSA. Is that correct? No. In rural municipalities, guys, particularly resort communities with contemporaneous micropolitan areas, can you clarify what area would be the appropriate for measuring the relative size of protected populations? So I don't think it'd be difficult. I don't think it's difficult to justify. It depends on the demographics. It depends on what you're trying to achieve. It depends on the narrowness. It depends on the outcome. Depends on the intent, depends on the effect. Like I said, I think that first question there, it's not as easy saying that would be very difficult to justify. It's whether you've gone to the analytical component pieces. I think it also, Denver MSA is I know, like we know it, and I used to do an AFFH thing and I had to have this segregation historically in Denver and make people think about it just like they would think about like Milwaukee or Chicago or Los Angeles. But I think it's just about the design still. Again, they're going to carry risks because of those demographics, but that doesn't necessarily mean that it's per se unlawful. Also, the justification could come up in different housing needs. And again, I think on the suburb side, when you have workforce requirements, the workforce is really important. The workforce is incredibly important because I think without naming name, I know people probably know a lot of different local suburbs in the Denver MSA whose workforce is much more, I'll just say greater diversity in the workforce than in the people living in the community. And that creates the justification is going to be, again, you're probably lowering the risk. For rural municipalities, this has always been a tough nut to crack. There's resort community people that I've talked with over the past 18 years on here, maybe. It's how it's operated. I think if you talk to some of the resort communities, one of the bigger problems over the course of since they've started doing workforce housing, again, you're going to have non-federal funding in this. You're at most going to have LIHTC. You're usually going to have state and local dollars. But I think the biggest hiccup has been the disability accommodation piece. Hiccup in both ways. Hiccup either in assessment. I think there's been a lot of correction towards assessing accommodations, but the demographics is tough. It's a micropolitan area and it's very small. And you're right. How do you look at that? I'll just give you an abstract question. I know Bernice has another question here. Oh no, she just left. So I'll just finish that. There was a time over a decade ago when some of the workforce housing preferences, I'll just say, not just in Colorado, but throughout the Rocky Mountain region, were sometimes very narrow, in which that the individuals who were availing themselves of the preferences were of different subsets of the workforce. That's about as taking more time. In other words, like the workforce itself was much more diverse than the area that the resort was located in. However, the workforce who was using the preferences to get in either homeownership programs or rental programs matched more of that micropolitan statistical area. I know there are some CCRD cases out there in the homeownership programs, but they've gone both ways. And I think they basically both on accommodation. I think there is an analytical piece, but this would be true of Colorado. It's a lot easier in my hometown of Cleveland to assess these race and national origin dynamics of some of the collar suburban counties and how they employ preferences, as opposed to thinking about the demographics of Colorado, just because the demographics of Colorado is predominantly white to begin with. So that's the statistical disparity piece. I think when we think about this, we're thinking about greater harm. And so that's a good way to analytically think, because is that achieving, if you have a workforce preference in place, you're likely have that with an intent to achieve an objective that is non-discriminatory on the basis of race and national origin. So doing that cross-check, I think that still could be employed in looking at the micropolitan area. Micropolitan area is usually, if you look at that AFUMP, I think Andrew asked the AFUMP question too. There's some breadth in there with those definitions. Micropolitan area, then you're probably trying to design a larger area to determine what to draw on statistically. But yes, demographically, statistics are going to kind of be tough on statistical significance, but that doesn't mean we can not still assess it for greater harm to achieve the objectives we're trying to achieve.
I think that's most of the questions we got. Any other questions anyone have? They want to put in the chat or come off mute, raise their hand.
I'll save we'll share the slides, contact information in the back if you want to brainstorm ideas. Again, especially that second portion. I was trying to end early the first time because I was hoping not to do what I usually do and just talk forever. But that second portion, all those scenarios could be an hour each. And we didn't even touch upon the different ways and nuances of models that communities are popping up across the country. So there's a lot of different ways to look at this, and there's a lot of different discussion points to be had. I think the important thing is, really, maybe it just comes back to the first part. Understand how to assess this and think about this from a lawfulness standpoint, and that's going to guide you through these creative preferences and models, which we have to create more integrated communities. I'll just close with, I'm excited about this from an evolution standpoint because it's filling that integration model and not that exclusion model. And it's very interesting to see how this has changed as a practice. So thank you very much. And
Yeah.
reach out with any questions. Happy to talk about it.
Thanks, James. I'm going to go ahead and stop the recording real quick. Right. Well, thank